A curator is anyone who has been appointed by the High Court of South Africa to act on behalf of another person and to safeguard that particular person's interests. This could be minors in instances where their legal guardians are absent in the sense of they either passed away, or they are nowhere to be found, or they are withholding consent to legal proceedings unreasonably against the minor that the minor wants to institute. Or alternatively, it could be regarding people with diminished mental capacity. So this could be anyone who cannot fully appreciate the consequences of their actions. That is a person with a diminished mental capacity. So this person cannot appreciate the legal consequences of the things that they do. They cannot function properly enough to administer their own financials. And sometimes they cannot even take care of themselves. So in South Africa, there are 3 legally recognized types of curators. There's a curator for litigation, which is also called a curator ad litem. So this type of curator concludes legal transactions on behalf of the patient, since we are speaking about people who are mentally ill or people with diminished mental capacity, and they tend to represent the relevant person in court proceedings. Because like we said before, the person with a diminished mental capacity is not in a position to fully appreciate the legal consequences of anything that they do. And then moving along, after a curator ad litem has been appointed to this person, then we need to establish whether or not the person can take care of their day-to-day needs, such as bathing themselves, such as taking medication properly, that sort of thing, getting their own groceries, and things of the like. So let's first start with the duration of the process. It all depends on what's going to be needed. It's a case-by-case basis. It could be less than 6 months, it could be more than 6 months. But I would like to have 6 months as my point of reference. So what needs to be done first? There needs to be 2 medical reports from recognized medical practitioners in South Africa that actually tell the court that these are the tests that we did, and based on these tests that we took, this is the conclusion that we make, that this person is not of sound mind. They cannot appreciate the consequences of their actions, and because of that, we recommend that there should be a curator bonis or a curator ad personam appointed to this person. But then now, in such an instance, one of the reports has to be by a psychiatrist in South Africa, as Rule 57 clearly states. And then after we received these reports, the person has to go to, an interested person or a party or a legal guardian of the child has to bring an application to court on an ex parte basis, meaning it's not against anyone, but it's just an application where you are requesting the court to appoint this curator ad litem and further a curator bonis or a curator ad personam to this person. And in your application, you have to prove why it is that you're the correct person to bring about this application, why you think this court is the one that has jurisdiction to hear your application. You need to state the full particulars of the patient, who they are, their sex, their general state of their physical and mental well-being, meaning you'll be telling them that, okay, this person can speak fluently, but they cannot count or they cannot even write their names, just to be as transparent as possible with the court regarding this person's state. And then you need to state your relationship between yourself as the applicant, the person who took it upon themselves to go and conduct this application, and the patient. And then now you need to also tell the court what it is that makes you think that the patient is of unsound mind. Maybe the patient is in a state where they cannot speak or they cannot respond to things properly, or they're just in a position where they no longer respect boundaries like a normal person would be able to respect boundaries. And then now you need to also state to the court the full particulars of the person that you want to see being appointed as a curator ad litem, a curator bonis, and or a curator personam. And you also need to get this consent from these people, because you need to establish whether or not they have the necessary capacity in order to act in that regard. They also need to state how long they've been doing this, because this affects the personal rights of another person. So it has to be someone who has experience in this field. And now this application now, that's just your main affidavit where you need to disclose everything. It needs to be supported by another affidavit, by at least one other person who knows the personal circumstances of the patient, to say, I know so-and-so, and I can attest fully that they truly are what the deponent in the main affidavit said they are. This is how they act. And I do think that this type of curator, it will be of great benefit to this person. And then another attachment would be the 2 reports by the recognized medical practitioners. Because remember, you first needed to have them ascertain whether or not this person was of unsound mind. Now they need to write a report detailing everything that they have done to establish that this person is of unsound mind. And then you need to annex that report for the court to refer to. And then now this will be taken to court. You'll get a court date, and then the first part of the hearing will be done, because this is a 2-part application. So a curator ad litem will be appointed in such circumstances after the court satisfies itself that, okay, you did provide us with all the necessary documentation. And then now after the appointment of a curator ad litem, bear in mind that the curator ad litem can only either be an attorney or an advocate of the High Court. Rule 57 does not allow for anyone else to act in that capacity. So now you need to provide the court order appointing that curator ad litem to the curator ad litem to say, we got an order on this day appointing you to act legally or over the person of this patient, right? So now what the curator ad litem is going to do is they're going to interview the patient and make a report of their recommendations and supply the court and the applicant with that report. So if they feel like they want to interview the prospective curator bonis and the prospective curator ad personam, they may, because it's within their legal rights and duties to do so. And they also need to add that onto the recommendations. And then now, after receiving the report from the curator ad litem, the applicant now needs to take all the documents that went to court, the court order, as well as the report of recommendations by the curator ad litem, and they need to deliver it to the master of the High Court. Now, the master of the High Court is then called to make comments on the patient's means, their general circumstances, and the suitability of the prospective curator bonis or the curator ad personam. So they will do their own little research, and then they will provide a report to you as the applicant for you to use that in your further legal proceedings. And then now you as the applicant, you can make a further application now, which is part 2 or part B of this application, to court for now the appointment of a curator bonis, or / in some circumstances it usually goes both, a curator ad personam on the same papers for an order declaring the patient to be of unsound mind, and the appointment of these various curators, which is a curator bonis or a curator ad personam. So if the court on that day is satisfied that, okay, you have given us all the necessary documentation that we needed to satisfy ourselves that this person is of unsound mind, then you'll get your order, and then you can start moving from there on. Oh, this is a very expensive application because there are so many people involved within the same transaction. You have your attorney's fees, first of all. So those could range between anything between 20 to 30,000 rands, and that's not taking care of the disbursements. There are traveling costs for you as the applicant and the patient to take the patient to the various medical doctors. There are the reports and assessments, which range between 5,000 to 18,000 rands. And then there are the curator ad litem's costs. So I think It could be anything between 50 to 80,000 rands if we are being honest. Could be more, it could be less, all depending on who you find and how quickly your things move for you. But I would say don't have anything less than 50,000 rands put aside for this application. So in one of the matters that I'm currently working with, there's a major child. She's about 24 years. But when she was born, she had really deep mental problems, to the extent that doctors did not even think it would be sufficient for them to put her on medication. She was mentally unwell from the beginning, and she has been mentally unwell since birth, essentially. Now, her mother passed away a few years back, and if she were a conventional adult, she would be getting her inheritance as the sole beneficiary to her mother's estate right away. But now she's currently of unsound mind, and she cannot appreciate the consequences of handling her own finances, to the extent that her uncle said that she cannot even write her name and she cannot even count money. If you give her a 1 rand or 2 rands, she'll know that this is 1 rand, this is 2 rands. But if you give her 100 rands, she won't know what that is or what it is used for. She doesn't know how to count. So she essentially needs assistance in every possible way in order to have someone who's going to be there to take care of her financial and manage her financial needs in such an instance. And then she also needs a little bit of help taking care of herself personally. If she's bathing, you'll find out that, okay, she didn't maybe wipe the face properly or this or that. So a curator ad personam will need to be appointed to such a person to ensure that this person's needs are taken care of. And then in another instance, I have a major male who only recently got diagnosed with dementia. He lived a full life. He had a wife. They never had children. They bought properties. And now he got dementia. So after having dementia, he had to be declared unfit or of unsound mind, like unfit to handle his own financial affairs now. Meaning he cannot even sell the house that he has because he does not appreciate the consequences of removing himself divesting himself of that ownership in the first place. So we need someone who's going to come in now and step up and say, okay, I will have to sign on your behalf as far as alienating your immovable or movable property for that matter is concerned.